Here.
Representative Grossel. Representative Hodgson. Representative King.
Present.
Representative Kulkarni.
Present.
Representative Lehman.
I'm here.
Representative Lewis. Representative Tate. Representative Watkins. Representative White. Representative Witten.
Here.
Co-Chair Lawrence, or Vice Chair Lawrence.
Yes.
Chair Gordon.
Here. We do have a quorum, and we will proceed with our business today. We have one bill on the agenda. It's House Bill 227. It's a very timely discussion and a very important bill. So Representative Lockett, if you will introduce yourself and your guest, we will, the floor is yours. And before we get started, I'm just going to kind of give the lay of the land. We're going to give about 10 minutes for testimony or for the presenting of the bill. Then we have several speakers lined up, so we'll have 15 minutes for those in support of the bill. We'll hear from some people that would like to see some changes to the bill, and then we'll have about 15 minutes for questions, and then we'll proceed to a vote. So the floor is yours.
Sounds good. Thank you, Madam Chair and members of the committee. My name is Matt Lockett. I'm the state representative out of the 39th District, and I will let my guests introduce themselves.
Good morning, Madam Chair. I'm Chelsea Yeoman. I am counsel with Alliance Defending Freedom, and I'm here to testify in support of the bill.
Good morning, Madam Chair, members of the committee. Will Schroeder, Senior Counsel for Attorney General Russell Coleman.
Welcome. And we do have a sub if we want to go ahead and adopt that. Okay. We have a motion and a second. Pfister, Representative Pfister on the bill. All those in favor say aye. Those opposed? The sub is adopted. Thank you.
Thank you, Madam Chair. Australia, Denmark, France, Papua New Guinea, Greece, and China, and India all have banned social media use for those under the age of 15. Other nations, including Norway, the United Kingdom, and several other EU members, excuse me, are currently debating or advancing legislation to introduce similar bans or to restrict age limits. All of these countries have one thing in common, and it's that they see the destructive nature of social media on our children, and they see that it is in their country's best interest to restrict its usage. We can all see that social media's harm to children is well documented. All of it has an addictive feature and design, and a brain exposed frequently to social media closely resembles a brain that is hooked on the most highly addictive drugs. Social media use causes declines in mental health and increases self-harm and suicidal thoughts. These social media algorithms, which we'll talk some more about later, quickly pull kids down dangerous rabbit holes of drug-related or sexual content. And every day, as many as 100,000 children receive sexual harassment on social media platforms, including sextortion and obscene. Here in the United States, we aren't outright banning social media usage by minors. However, there have been many states that have attempted to protect children from social media, and all of them to this date have failed. 100% of the bills that have been passed have been struck down in court. And I want to make it very clear that probably all of you know there is another bill that is in the House that is being pushed by a social media giant in our country that is the same language or very similar to all of these bills that have been struck down in court. Well, why would they do that? Why would they push that bill here? Because they know that it will not be upheld. They know that it is not constitutional, and so therefore they believe that if they can muddy the water with a different bill, then it will end in their favor. Arkansas, California, Florida, Louisiana, Ohio, and Utah have all been enjoined by courts. These laws enable what's called a, quote, one and done evasion, and they do actually raise free speech concerns. So here's the bottom line. Social media companies, the big ones that you can think of, the Metas, the Googles, all the rest of them, the TikToks, social media platforms already are performing age estimation. Why? They do it for ads and to sell ads to the users, which can be minors. And with that, I will turn it over to Chelsea for House Bill 227 explanation.
Yes, well, good afternoon. I am so grateful to be here with you today. With the advent of the cell phone, social media, and technological development that is developing at breakneck pace, the result has been an entire generation that has been experimented upon. A generation that has infinite amount of information and access at their fingertips. But what HB 227 is about is a very specific, nuanced, and legally tailored solution to the perhaps most dangerous piece of social media, and that is addiction. Social media is harmful to youth because first and foremost, it's addictive. A brain exposed frequently to social media closely resembles a brain hooked on the most highly addictive drugs. The dopamine releases also are similar in studies. Second, it damages mental health to be addicted to social media. It increases in harms like anxiety, depression, and suicide among our youth who are addicted to constant scrolling. We already mentioned that it exposes our youth to dangerous content and exploitation by bad actors. But beyond that even, we've seen that addiction harm in social media results in feelings of body image dissatisfaction, poor and disrupted sleep quality, including which leads to depression and anxiety, disproportionate harms to disadvantaged groups of children, so neurodivergent children, children who have less impulse control, maybe less emotional or social development skills, are particularly susceptible to the harms. As recently as this morning, Mark Zuckerberg is on a stand in California, standing trial, facing in the room with him hundreds of grieving parents who lost their children to social media addiction through suicide and depression. It's one of as many as 1,500 cases filed against Meta. Our children's minds are also not commodities because an addicted user is a very profitable user, including a lifelong user. That has come out in some of the discovery in these cases, is that these social media platforms are very aware that constant scrolling, autoplay videos, constant push notifications, the feedback loop is what children get addicted to, and that by using their data, by recording everything they do, every like, every conversation, every discussion, every video that's watched, every comment they make is recorded for life, they then profit off of it. HB 227 says our children are not commodities, that their data cannot be utilized to target them with ads. Their data cannot be utilized to target them with algorithms that are meant to addict them and continue that. It represents a shield in a world where our children are becoming victims to the greatest data wars, maybe in history, by some of the most powerful and wealthy corporations in history. HB 227 is very specifically drafted, and Representative did an incredible job ensuring that every single case that you may even hear about today in later testimony has been accounted for in the drafting of this bill. It protects the First Amendment rights of children, it protects the First Amendment rights of their parents, and even the First Amendment rights of the social media platforms. It's a purely content neutral bill. Addictive features are regulated, children are protected, and it does a really strong job of that. Thank you.
Thank you, Madam Chair, members of the committee. Will Schroeder, Senior Counsel for Attorney General Russell Coleman. I'm honored to be here and have the opportunity to speak in support of House Bill 227. Attorney General Russell Coleman fully supports this bill, and the office stands ready to defend it should it be challenged. Our attorneys have reviewed this bill and are encouraged that it is content neutral in every way and believe that it will pass a constitutional challenge should it face one. With me today is our attorney, Chris Lewis. He is the Attorney General's Division Chief of Consumer and Senior Protection, and Chris is at the tip of the spear. You heard about the lawsuits today out in California. Our office is engaged in a multi-state lawsuit, and Chris leads up that effort. Our office is currently engaged in major lawsuits with Meta, TikTok, and Roblox. We've seen the addictive nature of these platforms and have evidence of children as young as 6 creating accounts in a matter of minutes without their parents' knowledge or consent. This bill, as Representative Lockett just testified, puts common sense protections into law. House Bill 227 takes the same concerns being litigated in court and turns them into preventative public policy before the harm occurs rather than after. The fight to protect our kids online is the opioid fight of our generation. We're using the tools, all of the tools in the toolbox, and I'm grateful for your efforts to add one more. In closing, on behalf of Kentucky Attorney General Russell Coleman, we respectfully ask your support of this bill today. Thank you.
Thank you for your testimony. Thank all of you for being here. So we have someone that has signed up to speak in favor of this bill. Mr. Green, if you would come forward and state your testimony, please.
Hello,
Please introduce yourself for the record, and you may proceed.
my name is Jesse Green. I am the legal counsel for the Family Foundation. We are a Christian public policy organization that stands with Kentucky families and the biblical values that make them strong. Chair Gordon, committee, I want to thank you for giving me the opportunity to speak in favor of this important piece of legislation. First off, I want to thank the General Assembly for taking decisive action to protect minors in previous General Assemblies, specifically House Bill 278, also from Representative Matt Lockett, which protected kids from the harms of online adult content. And I'm very thankful that the U.S. Supreme Court recently upheld the right of states to enact those laws to protect Kentucky children. We believe that House Bill 227 represents the important next step in protecting kids when it comes to online harms. House Bill 227 is a well-crafted legislation that empowers parents to manage the social media activities of their kids, and it also protects them from harmful, addictive features that appear on most social media platforms. Parents have a long-standing constitutional right to manage the upbringing of their children. That right is consistent with the history and traditions of our country and extends for centuries. House Bill 227 empowers parents by giving them control over when and how their kids utilize social media. This bill does not ban their children from utilizing social media. Rather, it puts the parents in charge of the decision-making process and ensures that parents are giving consent when their children are utilizing social media. Additionally, House Bill 227 focuses on the addictive features that most social media platforms utilize in their services. It prohibits those social media or those companies from implementing these addictive features when minors have been given consent by their parents to utilize the social media platforms. This is important because numerous studies have shown that these addictive features are incredibly harmful to children, and the simple numbers back this up. Since the social media revolution, the depression rates amongst teens have more than doubled. Suicide rates have also skyrocketed during that same time. And the reason behind this, as Claire Morrell, author of The Tech Exit, explained to this committee in her written testimony, that the reason behind it is the social media platforms are designed to hook kids and addict kids so they continue to utilize their platforms as they become adults. In closing, I want to emphasize to this committee that House Bill 227 is a win-win for Kentuckians. This bill is narrowly tailored to address the major issues with the status quo when it comes to social media platforms, and that is a lack of proper parental control, and that is the addictive features that are incredibly harmful to kids. At the same time, it avoids the First Amendment pitfalls of eliminating anonymous speech, and also it does not burden the rights of adults to utilize social media platforms. House Bill 227 is a common sense policy that would make our Commonwealth safer for children, and it would also make it friendlier to parental rights. On behalf of our network of supporters and allied churches and pastors across the Commonwealth, I urge this committee to support House Bill 227. I also urge the full House to support it as well. Thank you for the opportunity to testify.
Thank you for your testimony. Okay. So now we will begin the testimony in opposition. Mr. Frazier, if you could come to the table. Okay, if you could both introduce yourselves, and you may proceed.
Absolutely. Thank you, Madam Chair. My name is Michael Frazier, and I am with the Foundation for Individual Rights and Expression with my good friend and colleague Ari Cohen. And we are here in today, and we had recent conversations with the bill's sponsor, and we look forward to working with him on this bill. But even with the committee substitute draft, we do remain opposed to the bill, not opposed in the reason why that the General Assembly has interest in this bill. We do not disagree with the need for it, but when we talk about the First Amendment and some of the countries listed here, I always go back to Whitney v. California with Louis Brandeis, and particularly in how we separate when James Wilson was writing the Constitution and was saying fiat lux when we ordain and establish our Constitution and set the new America experiment away from the doctrines of the Ode. What separated us in one of the special ways is the First Amendment. So we are not like the EU countries for good reason. Some of the EU countries we know are protecting pedophiles and being able to talk about that in their limitations of right to speak, including the UK. We don't want to be like the EU countries and some of the other countries. And we look forward, and my colleague Ari will get into how the First Amendment can be complied with this bill and how we look forward to working with the representative.
Chair Gordon, members of the committee, my name is Ari Cohn, and I've been a First Amendment lawyer for nearly 15 years, and I currently serve as lead counsel for tech policy at the Foundation for Individual Rights and Expression, or FIRE, a nonpartisan, nonprofit organization that defends the free speech rights of all Americans. We've worked for over a decade with the Kentucky General Assembly, including on passing the gold standard for campus free speech and due process, something we're very proud of. FIRE opposes HB 227, a bill that, while doubtless well-intentioned, would violate the First Amendment rights of both social media users and, frankly, the platforms as well. Let me start off by saying that nobody can credibly dispute that the government has a valid interest in protecting youth from harm, or that parents have a right to direct the upbringing of their children. Both are indisputable, both are important, both are fundamental and bedrock principles. However, that is not necessarily the question that needs to be answered in this case. A parent has a right to be free from government interference in the upbringing of their children, and a parent owes their children no right to free speech. And trust me, as a child, I tried it, they're not buying it. However, the mirror image is also true. While a parent has a constitutional right to be free from interference from the government, that right is not constitutionally assertable generally against private parties. But the government does owe First Amendment rights to minors. HB 227 does not regulate how a parent may or may not raise their child. Rather, it regulates how and whether minors may speak and access information online, and how private parties may speak to them. So the relevant question here is not what rights parents have vis-a-vis the government, but whether the bill would infringe on the First Amendment rights it owes to all, including minors. And as it stands, the answer to that is yes, in our opinion. As I just mentioned, minors are entitled to significant First Amendment rights, and only in very narrow circumstances can they be prescribed in a way that they couldn't be for adults. And those almost entirely relate to sexually explicit materials. And those are clearly not implicated by HB 227. So minors do have a constitutional right to access social media. But HB 227 would prohibit platforms from allowing a minor under the age of 16 to have an account unless they obtain parental consent. We've been here before. The Supreme Court expressly disapproved of laws that condition minors' expressive rights on the prior consent of a parent. When California attempted to ban the sale of violent video games to minors, the court rejected the argument that the law simply enforced parental authority, finding that what it actually did was impose government authority on minors, which a parent could then override. Because the exercise of authority was governmental and set a default of a speech ban that a parent could later override, the court found that a law prohibiting minors from engaging in protected activity unless a parent consents in advance must be unconstitutional. And the court similarly expressed doubts that punishing speakers for communicating with minors on the chance that their parents might disagree could ever survive First Amendment scrutiny. But beyond that bedrock constitutional issue, there are negative effects from a practical standpoint that a de facto speech ban could have, and it will harm at-risk and vulnerable youth the most. A single parent working multiple jobs to stay above water may not have the time, energy, knowledge, or wherewithal to provide consent, leaving an already isolated minor unable to find community, support, or other benefits of engaging online. But it's worse than that, because for many at-risk youth, the same people placing the youth at risk would be the ones from whom the minors need to obtain consent to use social media. In a challenge to a law that bears some, but not entirely, similarities with the provisions of HB 227, which has since been blocked by a federal court, as you heard, in Utah, FIRE represented two individuals who helped minors and adults trapped in abusive polygamous sects to escape. And I had a personal conversation with the founder of a homeschooling policy nonprofit. She has personally helped several youth who informed her that they were homeschooled not because their parents had ideological reasons for it or religious reasons, but because their parents were severely abusing them, and that reduced the chance of anybody seeing it. These children, having no frame of reference, didn't even know they were being abused, and they wouldn't have known unless somebody online who they had talked to had said, this is not normal, and you should not be experiencing this. You need to get help and get out. So cutting minors off from social media by default doesn't only deprive them of their ability to engage in entirely appropriate, enriching, and beneficial expressive activity, and to be clear, nobody also can dispute that harmful things do happen online, but it can also hinder their access to life-saving information and support. A second concern is the wholesale prohibition on the use of what are called addictive features in the feed of any user under the age of 16. These provisions also violate the First Amendment and also are in some cases preempted by Section 230 of the Communications Decency Act. Content recommended by a personalized recommendation algorithm, personal metrics indicating likes or reactions to content, notifications, awards, badges, and recognitions based on usage and site metrics. Those are all expressive in nature, and the First Amendment forbids laws that regulate speech on the basis of their content. And we heard earlier testimony that the law is content neutral, but if you listen, you'll hear that the harms that they are protecting against are things like body image issues and things like that.
And if you could wrap up, we have two other speakers slated to speak. Thank you.
And the Supreme Court has made clear that the reaction of listeners to speech, the impact, is not content neutral. The constitutional principles have led courts across the country to enjoin similar laws, and ultimately a law that sits enjoined and ultimately blocked protects nobody. Much better would be to take the time to craft a constitutional law up front, even if it takes a little bit longer, so that there isn't a segment of 4 years while this thing winds its way through the courts where nobody's being protected at all. The protection of youth is undeniably important and a worthy goal, but the First Amendment demands it not be achieved at the expense of free speech. We would be pleased to continue working with the sponsor to reach that goal in a constitutional manner, but as it stands, we currently ask the committee to vote no.
And we do appreciate the sponsor. We do recognize
Absolutely.
the intently crafted piece that he's done, and we appreciate that consideration. We
Thank
just
you.
disagree on the detail.
Exactly.
Thank you both very much. I appreciate your testimony. Next, we have someone that is testifying virtually.
Yes. Ms. Boss. BOS.
Ms. Boss, please introduce yourself and you may proceed.
Good afternoon, members of the committee. My name is Amy Boss. I'm the Vice President of NetChoice, a principles-based trade association dedicated to free speech and free enterprise online. NetChoice must respectfully oppose House Bill 227. We recognize and share the legislature's genuine intent to protect young people online. However, there is a trend of very well-intentioned laws that are passed, signed into law, and then struck down, ultimately putting us in the exact situation with no meaningful solutions in place. We echo the concerns that were raised earlier, that this bill does raise First Amendment concerns. The bill pressures platforms to restrict lawful speech based on vague standards, and courts have repeatedly held that government cannot compel platforms to act as speech regulators. Second, I do want to touch on the bill's age estimation mechanism, which we believe creates serious privacy risks. Section 2 requires platforms to estimate users' age with 80 to 90% confidence, using only data they already possess, and then restrict accounts accordingly. There is no commercially available technology that can reliably estimate a user's age from behavioral data alone at that confidence level. To even attempt compliance, platforms will be pressured to collect far more personal data than they currently do, including biometric information or government IDs, just to allow users to access lawful speech. That undermines privacy for everyone, not just minors. The Section 3 ban on addictive features is extraordinarily broad. The bill defines addictive features to include not just algorithmic feeds, but also push notifications, autoplay video, like counters, and engagement badges. Personalization is how platforms filter overwhelmingly amounts of information into content that is relevant, educational, and age-appropriate. Eliminating personalized feeds would push children towards unfiltered, chronological, or viral content that is often more extreme, less contextual, and harder for parents to manage. It would also undermine accessibility features and language preferences. Section 6 creates sweeping liability exposure. It allows private lawsuits for negligent violations and permits damages for emotional distress and mental health harm, with no meaningful standard for what compliance actually requires. That uncertainty will drive platforms to over-restrict content. We believe there are better proven ways to protect kids online and look forward to working with you on those solutions. We believe empowering parents with effective tools, supporting digital literacy, and enforcing existing laws against bad actors are far more effective than broad mandates that regulate speech. Thank you for the opportunity to testify, and I'm happy to answer any questions.
Thank you, Ms. Mann. If you will stand by, and we have another gentleman, Mr. Mann. If you would please introduce yourself and provide your testimony as well.
Thank you, Madam Chair, and I appreciate the opportunity to testify virtually today. My name is Tom Mann. I'm here with the Computer and Communications Industry Association, testifying in opposition to House Bill 227. CCIA firmly believes that youth are entitled to security and privacy online, and our members have designed and developed parental tools to individually tailor to younger users' online use to their developmental needs. For example, various services allow parents to set time limits, provide enhanced privacy protections by default for known child users, and other tools that allow parents to block specific sites entirely. This is also why CCI supports implementing digital citizenship curricula in schools to not only educate children on proper social media use, but also to help parents utilize the tools and the mechanisms that are already in place to protect their children as they see fit. While well-intentioned, the bill's requirements will inevitably lead to the collection of more sensitive data for young users and their parents. Verifying that an individual is a user's parent entails collecting some form of identifying document, and any document capable of verifying parenthood is likely to contain sensitive information. Requiring individuals to share sensitive personal information with third parties, including IDs or biometrics, can make recipients a prime target for identity theft, cyber attacks, or other data breaches. These dangers are only heightened by the bill's requirement that covered services retain such data. To avoid these problems, CCIA recommends explicitly allowing self-attestation as a reasonable method of age assurance under this bill, as this method does not require the collection of sensitive user data and also allows small businesses to compete with their more established counterparts. Again, I thank you for your time today and appreciate the opportunity to be with you.
Okay, very good. Presenters, if you will come back to the table, we will begin with some questions. I'll begin with my co-chair, Lawrence.
Man, one of the perks of being the co-chair, I guess. Thank you guys for coming here today. I did have a quick question, and I'm not a lawyer, so that's why I have this question. With us passing a state law like this, what is the enforcement arm of how do we as a state enforce this on a national company, I guess is my question. Because outside of the state, we have no jurisdiction. So how does that work? If you could briefly explain that to me.
Yes, so the Attorney General has, we would have jurisdiction within the Commonwealth, of course, and then also oftentimes, as currently is happening with the Meta case, we enter into multi-state cases, litigation, and Attorney Generals talk to each other, and when there's big tobacco, that was the first famous multi-state litigation when all the Attorney Generals came together and use their voices to talk to the tobacco companies and get changes made with the way tobacco was being marketed at the time. So that is currently going on with the multi-state that was referenced earlier out in California.
One more, if I may. So next, thank you for that explanation. That really clears things up for me. I don't really have a question. I have a quick statement. I was, just for reference, I was on my son's phone. He's 16. We were looking at Marketplace because that's what we like to do together. That's our thing. Buy junk and drag it home, and my wife fusses at me. So we were going through there, and as I was scrolling through his phone, we're looking at an ad pops up of an AI woman in a bikini. She then proceeds to lift her top, fully exposing herself. And I thought, what in God's name? I asked him, I was like, what have you been doing on this phone? He's like, I don't look up none of that kind of stuff. So though he's not looking for that, it is fed to his phone as a 16-year-old kid. So just want to make that point.
Representative Lehman. Representative Dotson.
Thank you, Madam Chair. To those who are in opposition, this question is for you all. I'm not sure if any of you guys represent one of the social media platforms and maybe can attest to this, but I pulled up a statistic or a study, I should say. In 2023, a team of Harvard and Boston Children's Hospital concluded that across 6 major social media platforms, that in 2022, annual advertising revenue from youth users from 0 to 17 years is nearly $11 billion. You would agree that those are huge profits being earned specifically off of selling our children's time and attention to advertising. So I would just like to ask if any of you all that are here today in opposition represent these companies, and how much profit do you see in that age group?
Do either of our presenters online want to comment on that, please?
I can start. So NetChoice, we represent a broad range of online businesses, some social media companies, some e-commerce companies, big companies, small companies, but including small platforms that would be caught in the crossfire of the vague liability standards like those in Section 6 of this bill. And I guess I would just point to, I don't have specific numbers for you, I apologize, but more fundamentally, I think the First Amendment does protect everyone, not just large companies. So when platforms, where my testimony is coming from, when platforms are forced to over-restrict content or collect more user data to avoid lawsuits, that's where we have genuine concerns and are coming from.
But you would agree that this is a huge part of their profit portfolio in that age group?
Honestly, it depends greatly among our member companies, the size. I don't know what percent of that it covers. I'm happy to get back to you. I don't have those numbers.
Thank you. Quick comment, Madam Chair. just want to echo the sentiments of our co-chair, Representative Lawrence. We need to put these parameters in place and guardrails. I have 4 grandchildren, and this is very concerning to me. I got a 12-year-old grandson that the very same things are happening, and I can see some minor changes in his behavior. So I do support this bill, and I do believe that we need to put these guardrails in place. Thank you.
Thank you. Representative Kulkarni.
Thank you, Madam Chair. Thank you, presenters and everybody that provided testimony today. This is a very complicated issue. This is a very complicated bill. I think the purpose and the intent of it is easy for everyone to understand, right? We want to protect our kids. We want to make sure vulnerable minds are not preyed upon or exploited by companies or individuals. I just want to understand or make sure that I'm understanding correctly what this particular legislation would do. And that is, in essence, provide parents more control over a person under 16, a child under 16 years old, from creating an account. Is that accurate?
This bill does a number of things. First and foremost, it requires large social media platforms, those with $1 billion in advertising revenues. So we're not trying to sweep in everybody but the big fish, so to speak, who are already, and I have their statements, using age estimation to sell advertising spots. There's a live bid on your feed for the specific spot. Part of the way that they get money for selling that spot is to say with a certain amount of accuracy what the user's interests are, ages are, demographics are. So they're collecting all that data. It's part of how the ecosystem works. And this says they must use that AI age estimation capability when they already do an estimate and understand that that user is 15 years old and younger to automatically shut down the account. And then if the child wants an account or the parents want them to have an account, they are absolutely allowed to engage and create an account and access everything they want and more through verified parental consent. And we heard a little bit about that earlier today. I was surprised to hear that this verified parental consent in the bill is a reference to the federal standard. It's already federal law that any internet provider, before they collect data on a child, obtain verified parental consent. The FTC regulates that. They have an entire website dedicated to what constitutes the consent and what does not. They're already supposed to be doing that to comply with federal law. And so this simply says that law has been unchallenged in 25 years. These groups have been doing this for 25 years. So these two aspects of their already corporate conduct that they're already operating in are now utilized to obtain verified parental consent. And at that point, the addictive features are regulated. And so for a child account, they're going to have a safer place when they have an account. That means no constant push notifications, auto scrolling. Push notifications have been identified to a specific harm related to interruption anxiety, with one study showing as sixth graders picking up their phones an average more than 100 times a day. And with a more extreme example being closer to 700 times a day. And so eliminating some of those auto scroll features, the features that have been known to be linked to depression, breaking up sleep cycles, neurodivergent kids being hyper overstimulated by being on their phone, it starts to say you have to have a safer playground there if you're going to have a child account.
Brief follow-up, Madam Chair.
Very brief.
quick.
We got several questions.
I agree. I'll be brief. I'll be honest. My main concern with any of this, anything around this issue, is the vulnerability of our kids who are being preyed upon, who are being groomed, who are being bullied. I don't know if this bill necessarily reaches that, because once they have been given parental consent, for instance, can this age estimation or age verification AI tool that you're using, can it be used to identify predators who are saying that they might be 16, but they're 45-year-old males in another country? How is it going to protect our kids from those people once they have been given parental consent to get online?
This bill doesn't address any content on the other side. That really is the responsibility of the social media platforms. But in terms of the age estimation, my understanding is how it works is within about 170 likes, Google has admitted that they can identify within a very close age range how old the user is based on everything they're already collecting about their users. And so I heard a statistic about a 97% accuracy rate among the tech platforms. And again, as their technology improves, they get to sell more ads, so will their accuracy and capability to protect children, I hope.
And Madam Chair, if I could just add to Representative's concerns, those are the Attorney General's concerns as well. And although they're not in this bill, they are very much part of some of the ongoing litigation. Thank you.
Thank you. Representative Grossel?
Thank you, Madam Chair. Thank you to the sponsor and the AG and everyone else for bringing this bill before us. I think it's certainly very well intentioned. One thing that I haven't heard mention of is algorithms, and I wanted to, it's one of the things that I think is most harmful for our teens, that they end up getting sucked down in deep, dark holes in terms of mental health and other things as it relates to algorithms. Is that something that you address in this bill or plan to address?
Yes, this bill phrases the term profile-based feed, and it is essentially the idea of they're taking the child's data and then feeding them content. So whether a child's watching 6 hours of cat videos or more nefarious content, the addiction harm is the same. And so this says that one of the addictive features that is not allowed to be presented to the child are feeds based on the data that's collected, targeted ads, but also a targeted algorithmic feed as well.
Thank you. One follow-up briefly, if I may. I have First Amendment concerns with this bill as it stands currently, want to be supportive of it, certainly respect my colleagues who have signed on as co-sponsors and the intent. I also have those user cybersecurity concerns. Sponsor, are you willing to continue to work on this with the folks that have presented today in opposition, perhaps via a floor amendment on the House?
Great question. Thank you for that. As I expressed before, yes, with the caveat of there's no promise to change the bill. I'm always willing to listen to concerns, always willing to negotiate as long as it doesn't change the main focus of the bill. I think there's a very big disagreement in terms of the rights that minors have, even given current Supreme Court cases which have not upheld that. And so I think in that light, we have to tread very carefully. And the greatest part about this bill is that it does tread very carefully. We were very careful to make sure that the rights of children and the rights of parents were not trampled. I believe it deals with those First Amendment rights. But to answer your question, yes, I am always willing to listen.
Thank you very much.
Representative Whitten?
Thank you, Madam Chair. Thank you, presenters and Representative Lockett. I just had a question just for clarification about the definition of the covered social media platform. You talked about that it requires at least $1 billion in gross revenues for at least one of the preceding 3 years. This industry is moving at such a fast speed that I'm almost concerned that if we put this into law and then say another media company comes up, would that not be covered? I just want to make sure that this definition covers what it intends.
Yes, if a social media platform meets the other criteria, which is that it's open to the public, it's a user-created account and primarily functions, this is functionality bill, to view, share, or generate user content, and they reach its $1 billion in advertising revenue, because advertising to minors is part of what this bill is about. Once they reach that threshold, yes, they would be required to comply with the law.
So until they hit that threshold, that would not apply.
Yes, and one of the reasons for that is we are uncertain how much technological capabilities the smaller companies have or are functioning in. We do know that the large ones are conducting age estimation by their own testimonial statements, and so we know that they're capable of that.
Thank you.
Representative Watkins?
Thank you, Madam Chair. Thank you to the sponsor, to all the presenters and whatnot on such an important topic that, quite frankly, I think is really complex. It has a lot of implications on privacy, freedom of speech, etc. I want to hone in on, just for my clarity, on this sort of concept of digital exposure and what is harmful or not harmful for the kids. And I know this is specific to social media, but I find, as I don't have children, but I have nieces and nephews that are that are on devices all the time, that also are on Netflix and any form of streaming service, every gaming thing known to man. What's the difference between Facebook's autoplay versus Netflix? And why does this bill only target social media and not the wide array of apparatuses that are exposing our kids to a lot of digital harm?
Sure. I think starting in a narrow place in light of some of the precedents that have come out, the broader bills have struggled to be upheld for a lot of reasons. Some of them were content-based regulations or considered overbroad. And so we wanted to start narrowly. And part of the other difference is the body of evidence on harms related to the addiction of social media is strong and becoming stronger. And some of that body of evidence includes things like harming the intellectual and social development of children and their mental health. It stunts their social capacity to get dopamine from more natural environments, from playing sports, from going outside, things that should be giving them natural amounts of dopamine. They're now getting it on the cell phone, which is a device in their hand. And so some of the addictive behaviors related to social media, that's where the harms, the body of evidence is coming from.
Thank you, Madam Chair.
Thank you. Representative Hodgson.
We've heard a lot from both sides about age estimation, which is a topic I was not familiar with a few days ago. But your bill says that you want the vendors to provide age estimation with an 80 or 90% accuracy rate. The folks online said they couldn't do that, and yet I read that they are selling their advertisers advertising based on the ability to do very precise age estimation and put people into buckets, let's say 12 to 18, something like that. So I guess I'm looking for a comment on the folks online. Can you give some backup to your statement that you can't do age estimation that accurately? Because it would appear that you are, and are using that, in fact, as a marketing tool to sell to advertisers.
I can clarify my comments maybe a little. I guess I would argue there's a massive difference between estimating age for personalization and estimating it to make a high stakes legal determination with liability attached. So I guess I would think of it this way. Weather forecasting models, you can say that it's going to rain with 70, 80% chance of rain tomorrow. And that's very useful to help plan your day. But it's not a model that's binding with a legal determination. So if platforms are held liable, they're going to want to know with accuracy, with extreme accuracy, and that would likely entail providing additional information, not just what is currently provided.
I can respond to that as well too. Excuse me. We know that companies are already doing this, and they do it for the sake of selling advertisements, and they know very accurately in terms of the age that they are selling ads to. We have example after example after example, and I know that you can't see this. This is actually it's 4 separate ads that appeared on Instagram, and they are ads for abortion. These are ads, if you can see, they're very colorful. They have little hearts. They have little stars. I'm pretty certain that if I'm on Instagram, I'm not going to be receiving one of these ads. These are clearly targeted to young girls. When these ads were found, these were on accounts of young girls. And so we know beyond a shadow of a doubt, not only through investigation, but through their own testimony from these large companies, this is happening already for the strict purposes of selling advertising. Yes, they are gathering data, but those that are concerned about the data being gathered, it's already being gathered. And so we, in this bill, want to say that you cannot gather the data to sell ads to minors.
Thank you. Representative Grossberg? Okay. Okay, great. Seeing no further questions, I would entertain a motion on the bill. Motion by Representative Dotson, second by Hodgson. Representative Hodgson, and clerk may call the roll.
Representative Dotson. Yes. Representative Pfister. Representative Grossberg.
Aye.
Representative Grossel.
Yes, may I explain my vote?
Yes, please.
Thank you. I do still have First Amendment concerns as it relates to your point on advertising specifically. I think any parent in the room can attest that their children spend a lot of their money, and so advertising is protected under free speech. I reserve my right to change my vote on the floor, but I'm happy to support this today because I think it's a well-intended bill and a great first step in the right direction.
Representative Hodgson. Representative King.
Yes, ma'am.
Representative Kulkarni.
Briefly explain, Mr. Chairman. I'm going to pass today. I have a couple of questions and points of clarification from the AG's office, and I think there's been a lot of discussion about some very specific points in this legislation. I want to really fully understand that, so I reserve the right to vote either way on the House floor, but I'm going to pass for today.
Representative Lawrence.
Yes, ma'am.
Representative Lehman.
May I explain my vote, please? Is that all right? Yeah, look, I've got a lot of concerns with this bill and the details of the bill, from privacy, cybersecurity, constitutionality, and speech issues. I think there's questions about the technological feasibility. You can worry about negative effects on innovation and free enterprise, and there's some interesting, and I'm not sure if they're really scientific kind of thresholds in here around the number of hours or days. I don't know if those, but I'm voting yes. I'm done with social media. I'm done with these manipulative algorithms. I'm done with the way they treat children. I mean, the people testifying in opposition to this offer no solutions. They just like to nitpick, and I'm not going to let good enough be the enemy of perfect in this situation. Thanks.
Representative Lewis.
Yes.
Representative Tate. Yes. Representative Watkins.
Briefly explain my vote.
Yes, sir.
I think this bill is well intentioned. I have a lot more questions about several of the issues that my counterparts and colleagues have raised as well. I also reserve the right to vote on the floor, but it's such a technically complex issue that I'd like to know a little bit more about before I cast that vote. Thanks.
What is your vote?
Pass.
Okay, thank you.
Representative White. Yes. Representative Whitten.
Yes.
Chair Gordon.
Yes. House Bill 227, as amended by House Committee Substitute 1, passes with favorable expression, and same should pass on the House floor. Thank you for your testimonies today.
Thank you.
This meeting is adjourned.